After the U.S. military operations in Venezuela that resulted in the capture of President Nicolás Maduro and his wife on January 3rd, many thought the Trump administration's campaign of lethal strikes against suspected narco-traffickers in the Caribbean and Eastern Pacific Ocean would wind down. But in the months following Maduro's capture, the strikes have only intensified. Since the last installment of this Murder on the High Seas podcast series, in December, there have been 36 reported strikes and 96 new fatalities, bringing the total to 57 strikes, 107 reported dead, 3 known survivors, and 12 missing who are now presumed dead. Just in the last 2 days, there have been 2 strikes killing a reported total of an additional 5 people. Today, we're talking about what's going on with this continued lethal campaign, as well as the military operations in Venezuela last January. We're going to break down the new legal developments in the landscape, talk about the prospects for accountability, and also what this all means in the context of a larger series of U.S. military operations that have violated both domestic and international law. This is the Just Security Podcast. I'm your co-host, Tess Bridgeman, co-editor-in-chief, and former deputy legal advisor to the National Security Council. I'm joined today by my co-host, Rachel Goldbrenner, who is executive director of the Reiss Center on Law and Security at NYU School of Law. Over to you, Rachel.
Thanks, Tess. Joining us once again to discuss the latest developments in the U.S. military's Operation Southern Spear are Rebecca Ingber and Brian Finucane. Rebecca is a professor at the Cardozo Law School. From 2021 to 2023, she was a counselor on international law in the Office of Legal Advisor at the U.S. State Department, where she previously served as an attorney advisor. She's written extensively on matters of presidential powers, international law, and national security. Brian Finucane is senior advisor for the U.S. program at the International Crisis Group. Before that, he served for over a decade as an attorney advisor in the Office of the Legal Advisor at the State Department, where he advised the U.S. government on legal and policy issues regarding war powers and military force. Rebecca, Brian, and Tess are all senior fellows at the Reiss Center on Law and Security. And so with those introductions, let's just dive right in. Brian, on the boat strikes, it seems like there was a slight lull for a little while, and then the tempo picked back up. Can you tell us about what's the current state of play, whether anything significant has changed, and how much do we know about what's been happening?
Right. So there was a lull after the U.S. military intervention into Venezuela for about 3 weeks, and then strikes picked back up, and they've occurred in both the Caribbean and Eastern Pacific. As Tess noted at the outset, they seem to have been uptick in the recent weeks. Under the direction of Donovan at U.S. Southern Command. These are now being posted on an almost daily basis by Southcom onto Twitter. And there seems to be a somewhat different framing of them, that the Donovan has framed these as total systematic friction. It looks like the Southcom is trying to backfill some sort of more traditional military rationale behind the strikes, while Donovan himself acknowledges that they're not some sort of cure-all for America's drug problem.
And Beck, since we last met, of course, the U.S. launched an operation on January 3rd that resulted in the capture of President Nicolás Maduro and his wife. We'll get into the legal arguments surrounding those actions later, but just to start us off, can you give us a rundown on that Operation Absolute Resolve and what's happened in the aftermath?
Sure. So I think we've discussed on prior episodes that in parallel to the boat strikes, the U.S. had been building up its military presence in the Southern Caribbean, pressuring Maduro, hinting at, and then I think fully threatening regime change. And as we know, all of this is happening while the administration is blowing up boats in the Caribbean and later the Pacific as well, and simultaneously rounding up people within the United States under a theory that Maduro had directed drug cartels to invade the United States through drug trafficking. So fast forward to January 3rd of this year, and early in the morning, the U.S. government conducted a large-scale strike across Caracas, the capital of Venezuela, captured Maduro and his wife and flew them out of the country. And as part of that operation, U.S. strikes hit targets in the capital and the surrounding areas, while soldiers raided the military complex where Maduro and his wife were residing. U.S. military and law enforcement then seized the couple. They flew them out of Venezuela, and a naval vessel then took them to New York, where they are both now detained and awaiting their next hearing in June. And I'll just say as background, Maduro had previously been indicted in the SDNY, the Southern District of New York, on a range of drug trafficking charges. And those charges were updated on January 3rd and then unsealed. And his wife was indicted as well that day.
Thanks. The boat strikes campaign and the pressure against the Venezuelan regime, which you've both discussed, initially seemed to really interrelate. But following the capture of Maduro in Venezuela, they have really seemed to diverge in both their rationale and objectives. So with Maduro and his wife in a federal court in Manhattan facing criminal charges, and on the other hand, the boat strikes continuing and even intensifying, how do you see that trajectory and what's the current aim now of the continuing U.S. military campaign? Brian, maybe you can take this.
Yeah, I think it's important to note that for the boat strikes, there are always a convergence of interests that were driving them. So saber-rattling towards Maduro was an interest on the part of the Secretary of State who was driving U.S. Venezuela policy, but that was not the sole interest at play. There were others who wanted to do war on terror and the narcos more generally, and doing strikes at sea was something of a consolation prize, given the potential consequences of actually doing drone strikes, say in Mexico against drug traffickers. And I think that remains true to some degree. But again, I think there's also an element of this becoming routinized and the strikes taking on their own sort of inertia here and proceeding on autopilot to a certain degree. As I said at the outset, it does seem like Southcom is trying to backfill a sort of more traditional military rationale behind them. How long these persist, I don't think we know, but the administration has continued to threaten strikes on land, and we've seen sort of ominous signs going out of Mexico. And at some point, they could redirect their focus from the maritime strikes to strikes elsewhere on land in the hemisphere.
Yeah, thanks, Brian. I think that's right. That once these strikes started as part of a named campaign with orders from the president on down, they do take on a life of their own, as it were. And I think the question of objectives and whether there is an exit strategy or how long these go on is one that folks ought to be asking. I think this would be in the headlines most days if it weren't for everything else going on in the world, which we'll touch on before we close out today. But to kind of keep the focus on these strikes, precisely because they haven't gotten the attention they should be getting. This is our fifth installment of Murder on the High Seas, and it's time to talk about crimes against humanity, unfortunately. So, Beck, maybe I can turn to you for this. Back in December, our friend and former colleague, Charlie Trumbull, published a great analysis on this issue. And we'd been talking about this question for a while as well, which is at what point do we see enough of these murders against a civilian population where they can be considered widespread or systematic attacks on a civilian population such that they would constitute crimes against humanity. So can you walk us through the analysis? What does it entail, and how do you think it applies here?
Yeah, sure. I'm happy to do that. And perhaps it's a good sort of time for a brief reminder on what we've discussed previously, because it's relevant here, right? What these killings actually are as a legal matter and what they're not, as both matters of domestic and international law. So each of these strikes, these are targeted killings of individuals suspected of crimes entirely outside of an armed conflict. These are best characterized under international law as extrajudicial killings. And as a matter of domestic law, they're murder. And so I want to just take a moment and clarify, these are not war crimes. You'll see we've seen a lot of just sort of lay mention in the press of war crimes with relation to these acts. I think people sometimes throw around those words casually, but those are legal terms of art. And war crimes are violations of the law of armed conflict, which only applies in cases of armed conflict. So this is not an armed conflict. We've talked about that extensively on this in prior episodes. And so that body of international law does not apply here. So as a matter of international law, again, these are extrajudicial killings. These are murder under domestic law. And as they have continued and expanded, this has, as you said, raised this question whether now they constitute crimes against humanity. And so Charlie Trumbull has that great piece where he finds that the strikes likely do qualify. And as he explains there, certain crimes, such as murder, torture, enforced disappearances can constitute crimes against humanity when they are committed as part of a widespread or systematic attack directed against the civilian population. And so let's just go through each of those elements, right? We could start with murder. I don't think there is much debate among actual legal experts outside the US government as to whether these crimes constitute murder. There is no armed conflict, as we've said. These are not combatants engaged in an armed conflict. They are simply members of the civilian population who are being killed on the basis of suspected crimes. And so the next question is whether these murders are widespread or systematic. And this is an either-or question. They do not need to be widespread and systematic. It's one or the other. So widespread means large scale. It's talking about the number of victims. They've killed almost 200 people thus far, and the administration seems intent on continuing. It's widened their reach. So it is quite possible that these would constitute widespread murders, but I don't know that we even need to draw that line because I think it's so clear on the systematic front. So the question there for whether these are systematic murders is whether these are random, isolated events or acts of violence, right? Or is this part of a systematic campaign? And on this, there's absolutely no question. The administration has been fully transparent about what it is doing and its intent to keep doing so. There's no accident here. Whether the intent is to target the people themselves or the boats in full knowledge that they are full of people with no plan to capture the people, this is a systematic campaign of violence, specifically murder, undertaken as part of a state policy.
And they've left a clear public and I'm sure, internal paper trail on this.
Even just Twitter alone, right? They videotaped it.
Yeah. So we haven't seen, right, the OLC memo. We know there is one. We know members of Congress have seen it purporting to bless the strikes. That's DOJ's Office of Legal Counsel. We haven't seen a concept of operations or the internal directive from the president to the Department of Defense to begin the campaign. But we know from Twitter alone, right, and also what's been said in the podium and other kind of public pronouncements, this is a named campaign with specific objectives against 24 cartels and criminal organizations, right? There's a very clear system around it that brings to bear what had previously been, it's kind of a combination, right, of the U.S. counterterrorism structure and the counter-narcotic structure, right, and bringing those together for a systematic campaign of killings. So I have to agree with you, Beck. There's really no way around the systematic element being met. So I guess the question then is, what does that change, if anything? Here on this series, we've been calling these murders and extrajudicial killings from the start. And as you rightly note, Beck, most experts have come to the same conclusion rather quickly. If these are, in fact, crimes against humanity, sounds like we're all in agreement that they should so qualify. What is different about that than if they were, say, just EJKs or murder?
Well, crimes against humanity are violations of international criminal law, and that carries with it criminal liability for the individual perpetrators. Here, that would be the U.S. officials that are involved in ordering or carrying out these attacks. So there could be a real risk of prosecution. I mean, as you know, I often think there's too much weight put on prosecution as the means of accountability for international law violations. But here, there is a real risk. And the ICC, the International Criminal Court, is, of course, one obvious place that people will think of. The United States, as many of our listeners will know, is not a party to the Rome Statute, which is the governing treaty of the ICC. But the ICC might nevertheless have jurisdiction if the acts are either taking place on the territory of a state that is a state party, or even a vessel that's flagged to a state party. So if any of these vessels are flagged to a state party, such as Venezuela or Colombia, that could be a possibility as a formal matter. I think as a practical matter, it's unlikely that the ICC is going to be the place that we see prosecutions of U.S. officials. I think it's much more likely that we might see prosecution in another state's own domestic legal system. So for us, that would be foreign courts. Because states may, under international law, exercise universal jurisdiction for these types of crimes that rise to this level. And there are immunity defenses that may be raised. We don't have to go down that rabbit hole here. And different states take diverging views on that. But the upshot is that U.S. officials could be charged in foreign courts. And one very real practical consequence of this, at a minimum, is that this could pose real constraints on the ability of such officials to travel internationally.
And here that would be, I imagine, from the president on down, right? It would be President Trump who ordered this campaign. It would be Hegseth, and it would be the senior most uniformed officials who are ordering and overseeing it. Presumably also on down the chain of command, although the identities of those people are, of course, much harder to know. And I think we would all agree that the true accountability should start with those who order, plan, orchestrate these kinds of killings, rather than the person, much farther down the chain of command. But presumably the government has asked each of those people to shoulder this burden now, to the extent they are involved in these operations.
Yeah, and of course, the president himself would likely get head of state immunity in foreign courts, but a former president, that is the states to choose whether or not to waive.
That's right. So I think, as you rightly note, Beck, there's a lot of focus when we say the word accountability on prosecutions, and it's obviously important and it has its place, but it's only one form of accountability, and it's probably not the most likely form of accountability to actually be effectuated with most military operations, but certainly with these. Brian, maybe I can turn to you on this, because I think you've actually even been involved in one of these proceedings. But let's walk our listeners through two different forms of accountability that we see playing out in courts and other dispute resolution mechanisms right now that are not prosecutions. So one is the civil suit that's been brought in U.S. federal court by the families of two Trinidadian men, Chad Joseph and Rishi Samaru, who were 26 and 41 years old, who were killed in one of the U.S. strikes last October while returning back to Trinidad from Venezuela. So that a case has been brought in federal court, raising two different kinds of claims. Separately, we have the Inter-American Commission on Human Rights, an ongoing set of proceedings about these strikes, in which I think you provided testimony, Brian. So could you just give us the state of play on each of those proceedings? Maybe let's start with Burnley v. U.S. That's the one pending in federal court, and then we'll turn to the ACHR.
Yeah, and just to give credit where it's due, I mean, the ACLU has really been the lead actor in a lot of this action, both domestically and internationally. So yes, there was a suit brought on behalf of the families of two Trinidadian men killed in one of the strikes. The claims advanced under the Death on the High Seas Act, as well as the Alien Tort Statute. And I should also say, in terms of U.S. domestic litigation, the ACLU has also brought suit under the Freedom of Information Act, seeking the OLC opinion that provides the permission slip for this killing spree. The ACLU also is responsible for prompting the Inter-American Commission on Human Rights to hold a hearing in March on the boat strike campaign, in which experts from the ACLU, the Center for Constitutional Rights, UN experts on human rights, and myself testified about the legal dimensions of the boat strikes. And there were also representatives from the State Department, from our old office of legal advisor, speaking on behalf of the U.S. government. The experts convened by the ACLU got really more into the legal weeds and the legal merits of the strikes, or absence thereof, framing that there was no armed conflict, as Rebecca just said, and that therefore these strikes implicate murder under U.S. domestic law and potentially crimes against humanity as a matter of international law. On the other hand, the State Department representatives did not get into the merits and really contested the competence and jurisdiction of the Inter-American Commission to even hear hold this hearing. And including on the grounds that there was an armed conflict, and the law of armed conflict was beyond the competence of the Inter-American Commission on Human Rights.
And so it seems like neither of these proceedings are obviously going to result in rulings or be resolved in the next couple of weeks, let alone months, most likely, right? But What do we think could be on the horizon for each of these? I think I would recommend to folks Ed Swain's great piece in Just Security on the Burnley v. U.S. piece, kind of noting all the threshold jurisdictional issues that are going to be raised here. It's obviously going to be interesting if they do get to the merits, because they're raising all of the issues that we've been talking about this whole time on this podcast. But in terms of whether they even get to that stage, there are going to be immunity claims and other, justiciability doctrines that are at play on the front end. Where do you see the IACHR proceeding playing out, and kind of what do they have the authority to do in that setting, to the extent they do side with the folks who brought the complaint?
Well, I just want to take a step back and think about this more generally, because I think that right now that the phase we're in the administration is that I think the value added by these proceedings, both in domestic court and before international tribunals, is to maintain the political and popular salience of these of the killing spree, keep it in the public eye, and not let these strikes become background noise. Okay, and that's beyond whatever ultimate outcome comes from the Inter-American Commission or from the suit in district court in Massachusetts. It's keeping this in the public eye, and I think that is really what's necessary to get what I view as the most politically relevant actor engaged here, and that is Congress. That is, in my mind, going to be the focus for accountability. Congress, both to engage in aggressive oversight, to unearth the facts, draw it out into the sunlight, and then actually for Congress to impose accountability. I view accountability is not just something that's located within a courtroom or an Inter-American Commission hearing room, but it's something that Congress can mete out, including by imposing consequences for personnel involved in the boat strikes.
And just taking us a step back, I think I completely agree with you there, Brian. One of the things that's interesting about the IACHR proceedings is you actually have two members of Congress, two U.S. Members of the House of Representatives, Joaquin Castro of Texas and Sarah Jacobs of California, who sent a letter to the commission urging them to scrutinize the administration's claims and taking essentially many of the positions that you've heard expressed on this podcast about there not having been an armed attack, there being no non-international armed conflict, these strikes constituting murder and extrajudicial killings, and saying they have been trying to use the mechanisms at their disposal to get some daylight and to get some accountability and have been failing. So I think it's really interesting to see members of Congress turning to an international body in that kind of posture. But as you say, Brian, there's a lot Congress could be doing. There needs to be a little bit of bipartisanship to get a lot of those things off the ground. But there certainly are things that even folks in the minority can be doing to keep the issue in the headlines and to keep the pressure on the administration to be answering for its policies here. One of the things that will be on folks' mind here, of course, is the War Powers Resolution. And for anyone who's listening to this right now, it's early May 2026. And the War Powers Resolution has been in the headlines because of the war in Iran. We'll touch on that a little bit later. But it's helpful to remind folks that there was a War Powers Resolution 48-hour notice filed for the boat strikes when the campaign first began, which did initiate the 60-day clock to terminate unauthorized hostilities. This is a tricky one because we're not in an armed conflict, but there are hostilities going on, arguably for war powers purposes, and that 60-day clock did run a long time ago. But the administration, of course, argued that the clock did not apply. Brian, can you just walk us through quickly what was the administration's argument? You wrote a great article about this on Just Security if folks are interested, but what is the argument that they put forward for why the clock didn't apply and why they don't need to terminate their strikes?
Yeah, this comes out of some great reporting both by the New York Times and Washington Post on briefings given to Congress by the Obstacle Council. And the argument that was presented in early November to avoid the 60-day deadline was that U.S. airstrikes on these boats in the Caribbean and the Pacific did not constitute hostilities because they were standoff strikes and because there was not risk to U.S. forces. The risk to U.S. forces was minimal. As I wrote about last fall, this argument does not withstand any sort of legal scrutiny as inconsistent with Congress's understanding when it enacted the War Powers Resolution as reflected in the legislative history, and also inconsistent with sort of the general context, which is of the 1973 resolution, which was that Congress at the time was very actively trying to shut down airstrikes, unauthorized airstrikes by the Nixon administration. And so, the notion that hostilities does not include airstrikes just really doesn't, withstand any sort of scrutiny or pass the straight face test. But that was the argument that the administration advanced to Congress, and the argument the administration has relied upon to continue this maritime killing spree up to just yesterday.
And that has been at the same time, correct, that the administration has claimed that we are in a non-international armed conflict. So even though for war powers purposes, it has said that these do not constitute hostilities, for the legal rationale, it has said that we are in a non-international armed conflict.
Exactly.
So this has been really helpful exploration of the boat strikes. But as we were discussing, there are sort of two strands that maybe began together and have diverged a bit. And the other is the operations that took place in Venezuela and what's happened after that. So maybe we can turn to that for a bit. And Beck, have you talked to us about the legal issues around the operations that happened in Venezuela? There are several moving parts to unpack here. You've written about it for Just Security. Can you walk us through the legality, the legal rationale in terms of both constitutional and international law for the operation that the U.S. undertook in Venezuela and the capture of President Maduro and his wife? And since we do, unlike as we discussed in the boat strikes context here, since we do have a publicly released Office of Legal Counsel opinion on the Venezuela operations, can you also talk about that opinion and what it shows about the administration's view of these domestic and international law issues and anything that might stand out to you about it?
Yeah, absolutely. I mean, as you mentioned, there was a sort of convergence of the different issues involving the boat strikes and the lead up to the Venezuela operation and capture of Maduro, and a divergence. And what's interesting is just listening to Brian describe the boat strikes, right? The administration is calling them a NIAC for the purposes of claiming the authority to kill and claiming that such strikes do not constitute murder, claiming that it's not hostilities for the purposes of the War Powers Resolution. And now we have an operation that involves the actual use of force against the state, Venezuela, and they're claiming that it's not war for the purposes of avoiding the need to get congressional authorization under the Constitution. So we do have this OLC memoranda that sets out to try to explain to us why that's the case, and it briefly addresses the international law issue, and so I'll talk about that first, and then I'll explain its how it goes through the domestic law. So on the international law side, I think we've talked about this on this podcast. The framework is governed by the UN Charter, which strictly regulates the use of force between states. And the general background norm is that the use of force is prohibited between states, and there are only narrow exceptions to this. So if the UN Security Council has authorized the use of force, or if a state is using necessary and proportional force to respond to repel an armed attack. So in self-defense, to repel an armed attack. Neither of those is applicable here. There's no UN Security Council resolution. There has been no armed attack from Venezuela on the United States, giving the United States the right to respond in self-defense. So there's really no plausible argument that the operation is lawful under international law. And I'll talk about in a moment how the OLC memorandum handles that. As a domestic law matter, the question is a procedural one. Who gets to make the decision to bring the country to war? Is it the president or Congress? And the Constitution assigns that role to Congress. But U.S. presidents have long claimed some independent authority to use force. And the question is, when does that cut into Congress's authority? Under the sort of framers' conception, it was the president can respond to repel an attack on the country, sort of in this most immediate sense. Congress has said in the War Powers Resolution that the president can use force unilaterally to respond to a national emergency caused by an attack on the country, pretty similar to that repel attacks concept. But executive branch lawyers have come up with a theory that the president can use force as long as it's not war in the constitutional sense. And so the way that plays out inside the executive is usually through the Office of Legal Counsel in the Department of Justice, which is OLC. It's typically asked to weigh in on presidential uses of force, in particular, the domestic legal questions that are involved. And what's interesting here is that this administration has released almost no legal justifications for its use of force across a range of circumstances, including in the boat strikes, as we've just said. It has also released no legal justification for its use of force as a matter of domestic law for the war in Iran. So the Venezuela memo is kind of a notable exception on the war powers issue. And so it gives us this window into how the administration lawyers this question generally. And some things really stand out here that have some broader relevance. The first is the memo's total dismissal of international law, and in particular, the UN Charter as a constraint on the president, at least in this context. It's possible to read the opinion as constrained to actions that the administration is calling law enforcement operations. But as we've discussed, the use of force against another state is, whether you call it a law enforcement operation or not, is as this was here, a use of force in another country that absolutely implicates the UN Charter and can only happen in conjunction with an UNSCR, UN Security Council resolution, or in self-defense to an armed attack. So the memo sort of puts that to the side and focuses almost exclusively, or at least says that it will focus almost exclusively on the domestic legal questions. So the memo also addresses the constitutional questions at issue here, and that's the real focus of the memo. And to do so, it cherry picks, I would say, from various legal arguments from administrations past to determine that this is not a war in the constitutional sense. So as an example of this, in the past, there have been memoranda that say, well, there is some short bombardment in this case, but no boots on the ground. Or there might be, well, there might be some small scale boots on the ground, but there's no preparatory bombardment. And in either case, we're going to make an argument that that's not war in the constitutional sense. And here the memo says, oh, well, we've got boots on the ground being okay there. We've got bombardment being okay here. We're going to put them together and say that even together now, that's acceptable as a matter of the president's unilateral constitutional authority. Interestingly, though, the memo authors, the lawyers, don't just assert that the president has this authority. Instead, they leave it to the president to make that determination himself. And so the memo repeatedly says throughout, the president could decide. And they're very clearly placing the president in the decision-making seat, including on these questions of law, like whether these actions arise to the level of war in the constitutional sense. And those are questions that past OLCs have typically taken on. Just one more thing to note about the memo are these concessions that it makes throughout. So this was to me the most interesting piece of the memo. So the memo concedes that there was no armed attack, no direct or imminent threat to U.S. forces, other than the threat caused by our own forces engaging in the first place. So it's almost, barely a step removed from conceding that there's no self-defense basis to use force under international law. And it also makes some concessions that are relevant to the ongoing Alien Enemies Act litigation. So the administration has been claiming in courts that Maduro was directing a Venezuelan gang to invade the United States through drug trafficking. And then the memo goes ahead and concedes that it has scant authority for such a proposition. And it even acknowledges that one of the few sources that it was given on this topic specifically needs someone else as the leader of this purported gang. So in other words, the OLC memo itself, the lawyers are undercutting in that memo the factual predicate for the Alien Enemies Act deportations, in addition to the factual predicate for the Venezuelan operation itself. And just finally, I'll just wrap up because I think this was really concerning. There is this theory in the memo that it's not war by virtue of not planning. And so OLC's traditional test for whether the president can unilaterally act asks, among other things, does this operation risk escalating into a war? Even if it's not a war right now, is there a risk of escalation? And prior memos weighed the risk of escalation very seriously, and they considered as favorable evidence of advanced planning to lower or prevent a risk of escalation. And here the memo takes a totally different approach. I would say an opposite approach. So as the lawyers explain it, well, we were told that there's no contingency plan for any instability that the operation might cause, or for what the United States might do in the event of major casualties, right? And because there's no contingency plan. We're going to treat that as absence of evidence that there's a risk of escalation to war. So the incentive structure this creates is pretty obvious and it's alarming. Don't make contingency plans, or don't tell the lawyers about them, or your plan will acknowledge the risk of war. And in so doing, we can just avoid any concern about escalation as long as we're not told that we're preparing for it.
Great, thanks. There's a lot there, Beck. I think you're also touching on an issue that you've written and thought a lot about factual predicates and whose determination it should be whether, as a factual matter, we are at war. Is that a factual question? Is that a legal question? Should courts be able to weigh in? If courts wade into it, is it a core national security matter and they should grant deference to those assertions by the executive branch?
Yeah, it's such a great question. And in my view, it's actually the heart of the Alien Enemies Act litigation, although I don't know that the ultimate decision will turn on it. But in those cases, the president has rounded up and deported people and actually shipped them off to foreign gulags in nations that they're not necessarily nationals of, in places where we know they will be abused, under a theory that we've been invaded by drug cartels sent by Maduro, that only he can decide, and that his own administration's evidence sort of points to the contrary. So this is a question at the heart of the boat strikes theory. In the Maduro context, in that operation, the question is, can the president just say that we're not at war? But in these other contexts, the question is, can the president just claim we're in a war, perhaps with some secret list of purported groups, based on his own theory that drug trafficking equals invasion or attack, and then kill people suspected of drug trafficking on that basis? And I think a similar issue is also at the heart of his threats to send U.S. troops to suppress protests in U.S. cities. In that case, might turn on a finding of insurrection or rebellion. And in that case as well, the question will be, is that the president's own determination? Or, and if it's the president's determination to make, is it then reviewable? Can courts address it at all? And so for me, this is a totally intertwined question of law and fact. And given how much power presidents have claimed in times of war or some warlike state, and how much of this both the courts and Congress have actually ceded to him over the time, I think that give the president's power to turn on this power at will, to just say 2 + 2 = 5, that seems to me to make that power limitless. And if you add to that the fact that the guardrails inside the executive branch are being raised to the ground, or when they do speak up, they're not being listened to, that level of unchecked and uncheckable power in the hands of one man alone would seem to me to be the definition of tyranny.
Brian, I would just ask if you have anything to add here. And in particular, also, we began with the operation against Maduro, and there is, of course, now this case proceeding in federal court. So if you have anything to add in general, but also anything of interest that stands out about that case.
Yeah, I mean, the prerogative being asserted here by the administration is that the U.S. president has a license to kill people based on his own say-so, his own determinations of the law and the facts. And the question is whether the American public and the U.S. Congress are comfortable with that as that asserted license to kill. I also like one of my favorite details of the OLC opinion is it confuses the Lebanese group Hezbollah with the Iraqi paramilitary group Kataib Hezbollah. Now, in terms of the litigation, the prosecution of Nicolás Maduro and his wife in the Southern District, this is taking a page from the Noriega playbook, where in 1989, the U.S. Invaded Panama, seized the Panamanian dictator, and whisked him off to the United States to face prosecution on drug charges. The Trump administration is doing something very similar to Maduro and his wife. They're facing narco-terrorism charges, drug charges, weapons charges related to alleged possession of machine guns, which would not be surprising given that he was the leader of Venezuela. There are a number of interesting issues, international and domestic law issues, that are likely to be played out in this litigation, including assertions of head of state immunity. At his initial appearance for the court, Maduro asserted that he is entitled to POW status. Some of these were previously addressed in the Noriega prosecution, but it'll be fascinating to see how these are dealt with in the courts here. I can't opine on the strength of the evidence, but the government's going to have to prove its case.
Yeah, we'll definitely be watching that and bring it back into another installment of this series as we see developments there. And before we close out, we promised we'd talk a little bit about the elephant in the room, which is that this is, we've been talking about two unlawful uses of the military here in the Western Hemisphere, which have both been overshadowed in the news by an even larger, in terms of its scope, war that the United States is waging against Iran, which began in February, which was also notified to Congress under the War Powers Resolution. It is unauthorized under domestic law. It's also unlawful under the UN Charter, violates the bedrock prohibition on the use of force except in self-defense or with Security Council authorization that Beck talked us through earlier with respect to the Venezuela invasion. And so we have on our hands a couple of different situations going on, right? We have in Iran what some of us have been calling a Tripoli illegal war. It violates the Constitution in the ways that have been, again, as Beck described with respect to the Venezuela invasion. It is up to Congress to decide when to use force abroad under our Constitution unless repelling a sudden attack. And even then, if you want to get into a full-fledged war, as happened in the aftermath of 9/11, for example, you go to Congress for authorization. Violating the UN Charter, this is true of both the Venezuela and the Iran operations. With respect to the Iran war that remains ongoing because of the blockade, continuing exchanges of fire, a continuing state of confrontation between the armed forces involved, you clearly have the War Powers Resolution 60-day clock having now been blown through because hostilities are ongoing. Contrast all of that with the boat strikes, and I think it's important to kind of keep in mind how these are the same, but also how they're different. With the boat strikes, there's not an armed conflict, and so keeping all of this right, trying to bring all of this together in terms of where we are. We have the Tripoli illegal war that's ongoing in Iran. We have the doubly illegal invasion of Venezuela, and then we have the doubly illegal for different reasons boat strikes campaign because they're violating the domestic laws, criminal laws on murder, and as a human rights law matter, are extrajudicial killings. They're also violating the 60-day clock of the War Powers Resolution. And as we've talked about kind of throughout this series of podcasts, the accountability question, the kind of how to even bring these issues into the light and make sure they're getting the focus they deserve, a lot of this boils down to Congress. And there have been votes under the War Powers Resolution on each of these things, on Iran, on the boat strikes, on Cuba, which we haven't touched on, but the administration continues to make threats against that country. Where does this leave us? In May of 2026, this far into the boat strikes campaign, with almost 200 people dead, having reached the conclusion now that we are seeing crimes against humanity being committed amidst these other unlawful uses of the military. Where should we go from here in terms of what is Congress's role and how we should kind of make sure these issues are getting the attention they deserve and that we end up seeing accountability?
Well, one thing that I would just want to say on that is that I think what we've seen is that Congress isn't really set up or doesn't have the muscle memory to deal with a campaign of extrajudicial killings by the U.S. president. Right? They have in the past criticized such things when they've occurred in other countries, and the U.S. government generally has done so. But the boat strikes have sort of gotten channeled into the general war powers conversation, in part because that's what Congress is used to, and that's what it's set up to do. And I think that's also why the war crimes language has predominated, right? It's just that is how people are used to critiquing or challenging the president on questions of the use of force. They're used to doing so in the context of war powers questions. Has the president been authorized to use force? Is this a war crime or is this acceptable under LOAC? And so we haven't yet developed a bureaucratic channel in Congress and language for talking about what is actually happening in the boat strikes context. And so one thing that I would like to see happen is a separation of the boat strikes campaign, as you say, which are a completely different animal from the war powers concerns that we see in the other context. There's good reason they've been combined, in part because the War Powers Resolution gives Congress mechanisms for addressing things quickly. And so we don't maybe have the same mechanisms for doing so in the context of a killing spree, that it's simply murder. But I think it confuses things in the minds of the public. And so I would like to think strategically about a way to separate the two in people's minds.
And so just to pick up on what you just said, Beck, which I think is really important about separating out some of these questions that are really distinct, but also to maybe push back a little bit on the question of whether Congress is equipped to handle this set of issues. It certainly doesn't have the muscle memory right now, but it does, it's an institution that's been around for a long time, and we've seen not, this exact fact pattern. Obviously, this killing spree is new and troubling and dangerous in lots of ways we have not seen before. But we have seen gross illegality on the part of the executive branch. And we've seen Congress set up commissions of inquiry, specialized high-level bipartisan panels. There are things that they can do if they want to get to the bottom of something as a fact matter, as a law matter, and to hold folks accountable. We have not seen them exercise that there. Here, I think in large part, we would all acknowledge because of the hyper-partisanship that is, undermining Congress's ability to speak with one voice on some of these really most important issues of the day. But they certainly have the tools if they should choose to use them. But they haven't thus far. And as you say, Beck, I think that's exactly why some folks are turning to the War Powers Resolution, because it gives you this hook of these expedited procedures to at least get folks on record. Do you support or do you oppose what's going on here?
I agree with that entirely. And I think it's really important to focus on historical episodes, because I think people have a hopelessness right now, this idea that if Congress can't stand up and stop the president immediately, that, the suggestion is, well, they're useless. That they don't have the tools, and there's not going to be any accountability, or there's no ability to stop them. And I think it's important to look through these periods in history. This has not just been one uphill climb toward presidential claims of power and Congress completely ceding power. There have been times of overreach by presidents in the past, yes, but there has also been significant pushback, and Congress has reclaimed its powers. Congress has engaged in major reform, set up commissions to investigate prior abuses, from fraud and mismanagement to major war powers concerns. And so I think that's all cause to believe that they can do so again. And we have to push them to do so. And it will take some time.
Yep.
I also do think that Congress is not the only game in town. We've spent a lot of time talking about the courts, and while certainly being aware of the reticence of courts to get involved in these kinds of matters, I do think the two cases that we talked about have the potential to test some of the legal theories and facts that the administration has put forward at various times if they are permitted to proceed. So I would, for one, would be watching those court cases as well.
Yeah, and I think, and maybe I can turn to you, Brian, for a little bit on this. When we're talking about the Venezuela set of issues, and of course the Iran war, which isn't the main subject of this podcast, but when we're talking about the bucket that is, where war powers is the right framework to be thinking about a couple of the main issues involved. There are viable proposals for war powers reform that many of us on this screen have been involved in crafting and putting forward. Where do you see that bucket of issues fitting into, how we're seeing oversight, either the lack of oversight or potential future oversight play out?
Well, so I think there is a potentially robust agenda for oversight by the next Congress. I think that people should be thinking about historical episodes like Iran-Contra hearings, like the sort of hearings in the 70s with respect to Watergate, the abuses of the intelligence community, then the Church Commission, things like that. Yes, I think the next Congress would probably be an opportunity to start building momentum for war powers reform to try to prevent some of these abuses in the future. Hopefully, the rampant executive lawlessness we've witnessed over the last year plus will inspire people to move in that direction. I also think that we have a very recent lesson of this administration falling back and retreating in the face of congressional pushback and public pushback. And that was respect to calling people terrorists and executing them in the streets of Minneapolis. Okay. And they attempt to deploy the same sort of playbook domestically, did not turn out well when the administration tried to label Alex Pretty or Renee Good terrorists after they gunned them down. And so I think if Congress is able to muster the political will and able to have the funding fight, even under the next Congress, there is the potential, I think, to use funding cutoffs or a funding fight to shut down the killing spree at sea.
Well, thank you. I think we've tried to end on a note of talking about what can be done going forward in terms of the role of the courts, which is hopefully, with respect to the boat strikes in particular, not nothing. The role of Congress, which is obvious, but there's many fruitful avenues in terms of oversight, using their power of the purse, and simply using their bully pulpit, in addition to actual legislation, whether it be legislative reform or individual, cutoffs, and the like. And then, of course, importantly, just keeping this set of issues, in people's minds, and remembering that if we weren't in this war in Iran, if we didn't have so much else going on both on the domestic and international plane, we would be talking about this every day. This would be the big issue. It is still a very big issue, and so I'm grateful to all three of you, my co-host Rachel, and to Rebecca and Brian, for continuing to talk us through these issues and make sure that we stay on top of what's going on and keep thinking about what could come next. This episode was co-hosted by me, Tess Bridgeman, and Rachel Goldbrenner, and cross-posted by Just Security and the Reiss Center on Law and Security at NYU School of Law. It was produced by Maya Neer, with help from Pooja Shah, and with research support from Marie Miller. A special thanks to both of our guests, Rebecca Ingber and Brian Finucane, for joining us again.
This episode, part 5 of the Murder on the High Seas series, is part of Just Security's collection, U.S. Lethal Strikes on Suspected Drug Traffickers, Operation Southern Spear, Operation Absolute Resolve. You can listen to installments 1 through 4 of Murder on the High Seas wherever you get your podcasts, or watch them on Just Security's YouTube channel. Those episodes, along with additional resources for further reading, are linked in today's show notes.